as people are still trickling in, but we have a lot to get through today. So I'm very excited to introduce the fourth in our flagship Cornerstone Climate Litigation Lessons from around the globe, presented alongside Mishcon Purpose. And this will be focusing on South Africa, one of what I think is the most interesting jurisdictions that is dealing with a wide range of climate-related litigation, and has had quite an interesting history of climate-related litigation. South Africa is a fascinating jurisdiction for us, certainly from the UK, because there's a strong common law tradition in South Africa, alongside quite a strong sort of statutory set of codifications of various rights, and all against the backdrop of a very strong constitutional and human rights backdrop. Plus, there's also interesting issues around customary law and indigenous communities. So bringing all of that together in the context of a country which is facing one of the most difficult of the climate transitions, a very vulnerable community or set of communities, where there's a lot of reliance on high greenhouse gas emitting areas of the economy, which will all need to transition at the same time as very high vulnerability to the impacts of climate change. So it's a real cauldron for the development of climate litigation, especially since there is a very long history of public interest litigation in South Africa. And so our speakers today will be bringing all of that together in their presentations to you. And I will introduce them each in a moment, but just to let you know how the session is going to be running. Each panelist will speak for 10 to 12 minutes. And then we'll all come back on screen together for a set of questions afterwards. Please, if you have any questions, pop them in the Q&A. Thank you to those who asked them questions on registration. We will try to get to them too. The slides that you will see, you'll be able to spot the barristers/advocates on the call by who uses slides and who doesn't. But the slides that have been produced will be shared with you afterwards, and there will be a recording made on the Cornerstone Climate website. I should have said right at the outset, but for those of you who don't know me, my name is Estelle de Haan, King's Counsel. I'm a silk at Cornerstone Barristers, involved in the climate litigation in the UK, but you might not realise that I'm also called in South Africa, having done quite a lot of my legal education there. So this is a webinar that is very close to my heart. So let me introduce our excellent panel of speakers. We will start off with Advocate Ruth Kruger, who is an advocate practicing at Thulamela Chambers in Johannesburg, and her legal work is enriched by her background as a sustainability scientist. Her practice is primarily in public law with a focus on environmental law, and she appeared for the amicus curiae, or the intervener, the VAL Environmental Justice Alliance, in South Africa's first youth-led climate litigation. She's also got a really interesting practice looking at biodiversity and the link between environment and animal rights and climate liability of carbon majors. We'll then go on to Wandisa Palmer, who is the Executive Director of the Centre for Environmental Rights, a non-profit organisation and law clinic based in Cape Town, which has been the instructing attorneys or the instructing solicitors effectively for a number of the main climate cases in South Africa. And Wandisa is a human rights lawyer and social justice activist with over a decade of work holding various roles in public interest law and social justice in South Africa, including litigating climate and environmental cases, cases on the inclusion of community voices, holding financial institutions accountable for their role in human rights abuses and the projects they finance. So again, a very wide purview. We'll then go on to Advocate Chris McConaughey, who is an advocate in Mazel's Chambers in Johannesburg. He also has a public law and human rights practice with a focus on climate change and environmental rights. And he was involved in 5 of the 10 climate cases that are listed on the Sabin Centre's climate database. He's also involved in litigation and advisory work covering a large range of climate issues, including shareholder activism, pollution control, renewable energy development, and loss and damage claims. And then last but certainly not least is Lozola Kati. Lozola is joining us straight from protest on acid mine drainage in Mpumalanga, which is the area of South Africa where mining communities are most concentrated. And so she won't be on screen when she does her presentation, and she may have some issues with joining us. So we'll hope that Lozola rejoins us for the end of our session. Oh, there she is. She's popped up again. But Lozola is the fossil ad ban coordinator at Fossil Free South Africa, which is a network of South Africans calling for divestment from fossil fuel companies and for restorative reinvestment in sustainable energy. Hi, Lozola. And she's a specialist and practitioner in the fields of social justice, climate change, and greenwashing campaigns with over 8 years of project management and campaign experience. So with that introduction, I will hand over to our first speaker, who is Ruth. Do feel free to share your slides and start your presentation.
Thanks very much, Estelle. Let me just try and share.
All our careful practice.
Indeed. All our careful practice.
If you can't share, oh, there we go. There we go.
Go.
Excellent. Thanks, Ruth. And you'll just need to slideshow it.
Yes. There we go. Everyone can now see my slides. I'm sorry about the whole that. As you can see, lawyers are not necessarily very tech savvy. First of all, thank you very much, Estelle, for the welcome and introduction. As you've heard, my name is Ruth Kruger, and I will be opening this discussion on climate litigation in South Africa. More specifically, I'd like to speak to you today about amici, aridity, and administrative law. So to kick that off, thinking particularly about aridity, I wanted to touch on the reality of climate change in South Africa to ground our discussion. As in many places in the world, climate change is making itself felt through extremes in South Africa. In particular, we have far too much water at some times and in some places, and far too little at other times and in other places. The picture on the left of the screen is a picture from the recent floods in the Eastern Cape in South Africa, which is a very poor province in South Africa. The death toll from those floods was over 100. And we've seen flooding events quite commonly in the last few years. In 2022, in fact, a national state of disaster was declared as a result of the flooding. On the other hand, in the picture on the right of the screen, you can see a promotional image, I suppose you'd call it, from the time when we were all very concerned about day zero, which would have been a circumstance in which Cape Town would have become the first major city in the world to completely run out of water. That didn't happen, luckily. But other municipalities in the Eastern Cape did actually reach day zero, and we don't talk about that enough. The point, though, is that we're confronted increasingly by extremes, many of which center around water. And how do we respond to that? As lawyers, as litigators, we only really have one tool, and so we're responding through climate litigation. I'm not going to go through all of these cases because I think others will be, and also because I don't have time. But I wanted to point to some of the limitations that we're seeing as the field of climate litigation emerges. The first of these limitations that I'd like to discuss is that we need to think about what we consider climate litigation and what we don't, what's included in the definition and what isn't. The Sub-Center, which Estelle was mentioning before, and which has a wonderful, wonderful database of climate litigation across the world, their definition of climate litigation is on the screen. Cases brought before judicial bodies in which climate change law, policy, or science is a material issue of fact or law. And so far, so good. But that's a definition that has been criticized quite heavily by Mishcon and Tigray and others, because it tends to focus on climate litigation as seen in the global north, as it is relevant in the global north. If the focus is very much on mitigation, while in the global south, we often confront issues of adaptation, of cases that might be located in social concerns, in social challenges, and might seek to rely on socioeconomic rights rather than environmental rights. Despite that different focus, they arguably, though, are still climate litigation cases. And when I think about these issues, when I think about this definition of climate litigation, it makes me think of research that I did some years ago in Mpumalanga, which, as I mentioned earlier, the province that has so much of our coal-fired power production in South Africa. I was doing research in a town that is sort of nestled between coal-fired power stations, and the people that I spoke to about challenges that they were facing spoke to me very much in rights language and spoke about their problems in access to healthcare and access to work, in poor air quality and health challenges. All of these, of course, are very real challenges, but they're not dressed up in climate rights, climate litigation language, nor do they acknowledge the ways in which they are tied into issues around environmental justice or energy justice. Because that language or that linkage is often missing. Our courts don't see the linkage either. And to be honest, our courts don't necessarily see the linkage even when it is expressed. I think that this issue around the definition is a challenge to the development of climate litigation in South Africa. And there are 3 cases at least where I think we haven't acknowledged their potential from a climate litigation perspective. The first of those is deadly air, where arguably it has been most acknowledged. Deadly air is a case about air pollution. It was a case in which dealt with the terrible standards of air quality in the high veld in Mpumalanga, which we've been speaking about. And it did lead to a declaration that the poor ambient air quality in that area is a violation of environmental rights. So the focus was on air pollution rather than on climate change. But it wasn't acknowledged that air pollution actually does, in and of itself, contribute to climate change. Nor was it acknowledged that there are definite links. Well, I think perhaps in the pleadings it was acknowledged, but certainly in the judgment it wasn't acknowledged that the case was also one of energy justice and environmental justice. I also think in cases such as these, cases involving air pollution, one needs to remember that energy production issues are really the flip side of climate change issues. And that's why I would see deadly air as definitely as a climate litigation case. The second case I wanted to mention is the Vaal River Development Association case. I'm just keeping an eye on the time. And that was a case about a sanitation catastrophe on the Vaal River, which came about as a result of electricity being cut off. And that led to discussions in court and outside of court around a potential right to electricity and whether one could find that in other constitutional rights that we have. It was ultimately held that we don't have a right to electricity in South Africa, but the human and social catastrophe that came about as a result of electricity having been cut off and sewage leaking into the river, all of that was acknowledged as being clearly linked to the failure to provide electricity. And this case, I think, is important from the perspective of climate litigation because it addresses the rights framework around the provision of electricity, specifically in a context like that of South Africa, where electricity is almost entirely produced through coal-fired power stations. It's a case that deals with rights that we really need to be cognizant of as we engage in issues concerning electricity production and electricity use, as we must do if we are discussing climate change and our responses to climate change. The third case I wanted to highlight is the Riddle case, which was a defamation case. The respondents had said something, had criticized an Australian mining company and worked with a SLAP suit, which is strategic litigation against public participation. And our Constitutional Court recognized actually that that the SLAP defense, while not an offense that stands on its own, is a defense that can be accommodated in existing defenses to defamation that exist in our law. This is a climate litigation case in my mind, because it's about how we respond to big industry, how we might respond to carbon majors, what we as citizens are allowed to do in response to the entities that are contributing to climate change in a significant way. Now, the second big limitation in climate litigation, as we see it in South Africa at the moment, that I'd like to discuss today, is the fact that most of our cases are rooted in administrative law and administrative justice. Now, administrative law is, well, there are many benefits connected to administrative law. It is, in South Africa, it's entrenched in our constitution, it's entrenched in legislation, it's very well established, very well understood. It's also neutral in that it's much easier to look at a decision made by a public body and think about whether it was lawful, whether it was reasonable, whether it was procedurally fair. It's much easier to do that than to make a decision between development and climate change impact. That leads to a whole lot of politically charged discussions, which can be quite difficult. And way around that, I think, can be through administrative law. Now, this reliance on administrative law has led to some very exciting successes in our climate litigation. We've seen in the Thabametsi matter, we've seen the recognition that climate change impact must be considered whenever developments are approved. We've also seen more recently in the Cancel Coal matter that considering climate change impact also means considering the impact on children, particularly, and the fact that these rights need to be considered when climate change impact is considered. However, I wonder whether this reliance on administrative law has led to an over-reliance on procedure, which I think can be a bit hollow. If that is our form of climate litigation, if we can only do it through administrative law, then I might suggest that we haven't developed our thinking around the law around climate change sufficiently, and we haven't thought sufficiently about the rights matrix surrounding that either. We also need to remember, I think, that administrative law tools, as we sharpen them, to use them against, in combating decisions that harm the environment, those same tools can be used to challenge decisions that seek to protect the environment. For example, I think administrative law tools have been used recently to combat decisions to develop renewable energy in the UK. So it's, I think administrative law is sometimes dangerously neutral. So in that context then, I think it's useful to, just looking at the time, I think it's useful to think about these challenges, but also think about how we can combat them. And one way one might consider is through the use of amici, or I think in the UK you would call them the interveners. We would call them in singular amicus curiae, or plural amici curiae, for short amici. Now, in my personal experience, amici can be very useful in dealing with some of the limitations of human rights litigation, and specifically climate litigation. They can be a way of addressing blind spots. For example, in a matter I'm involved in, I'm acting for the Biodiversity Law Centre, and specifically pointing to biodiversity concerns in the development of a special economic zone. Those are concerns that have not been raised by any of the other parties. The other parties are raising important social and environmental concerns, but they aren't seeing the biodiversity concerns. And we are, I think, highlighting that blind spot Amici can also provide a scientific basis for argument in another case, which isn't an environmental case, but I think is relevant. Another case I've been involved in is one challenging the way in which consent is understood in rape cases. It's actually for the Psychological Society of South Africa there. And we were able to provide a great deal of scientific literature because the Psychological Society is, that is their area, they're experts in that. And I think that added to the litigation significantly. The third example I wanted to bring up is that of the cancel call matter, which I think others will also be mentioning. Cancel call is a challenge to the expansion of coal-fired power in South Africa. And I've been acting for the NGO Section 27 in that matter, which is a socioeconomic rights NGO. We sought specifically to introduce the new concepts of intersectionality and also the linkages between environmental and socioeconomic rights. Again, I think these are useful things for the court to hear. Having said that, and I am coming to my end, I know I'm running out of time. But I did just want to say that, particularly in the cancel call matter, the experience was not exactly straightforward. In bringing up intersectionality, the response we got from the judge was, intersectionality is just a theory, and I can't even spell intersectionality. Another response we got when bringing up issues surrounding, I suppose, environmental and energy justice, the response we got from the judge was, the people living next to power stations could just move. So it was something of an uphill battle. And that led me to think quite a lot about the role of amici and how one can truly make amici useful in the context of climate litigation and other human rights litigation. I think the first point is that one shouldn't make any assumptions. We need to remember that climate science is new and is evolving, and that we're all coming to grips with it. And we need to help the courts to do so. We need to recognize our role as judicial educators in a way. We also need to be careful, very careful, when we are bringing in thoughts and ideas from outside the traditional legal field. I mean, for example, intersectionality is actually a concept that our Constitutional Court has recognized, but it is a new concept and it's outside the traditional legal field. So I think we should probably have talked through it more carefully. I think I see Estelle popping up on the screen and I'm almost done. Yes. Yeah. So I think we do need to be very careful of that. We also need to, well, no, not need to anything. I think it's useful to remember that we do have an appeal process at our disposal. In the cancel call matter, for example, the applicants won. It was definitely a success for climate litigation. But the win was on very narrow grounds, and the judge actually held that the equality right was not implicated. So he was specifically distancing himself from the intersectional impact of climate change. The other side, the state respondents, now appellants, are appealing. And we're quite pleased about that, actually. We're hoping to get a better judgment. And yeah, I mean, in general, I think it's important to remember that the role of amici is to some extent one of influencing the discourse, of peppering the discussion with thoughts and ideas and hoping that eventually some of them will stick. So in that context then, alute continuum, and thank you.
That's fantastic. Thank you so much, Ruth. And you're absolutely right to remind us all that we are involved in something of a judicial educational exercise often. So yes, if I can ask you to stop sharing your screen, and you've got a couple of questions, but we'll wait till the end, and I'll invite Wandisa, please.
Thank you, Estelle, for the invitation, and good afternoon, everyone. And thank you, Ruth, for kicking us off with that background and overview of where South Africa finds itself in the climate context. I'm going to touch on a couple of cases, about 3 cases that we've worked on here at the Center for Environmental Rights that are climate cases, using a broader definition based on what Ruth has just presented. But before I do that, in addition to the background that Ruth has sketched, one must understand that this work is happening in a context where South Africa as a country is heavily reliant on coal as a means for energy generation. And it is a well-known fact that climate change is exacerbated by fossil fuels. And for decades, as a result, civil society organizations have been calling for a just transition away from coal, away from the burning of fossil fuels and mining, towards least cost energy sources such as renewable energy. Currently in the country, there's a lot of work being done on the just transition to respond to the climate crisis. And this work goes beyond just a transition in terms of energy generation, but is aimed at responding at the climate crisis while also responding to South Africa's specific challenges of inequality, poverty, and unemployment. For us who work in this space, we consider this work on the just transition that as a country addresses the climate change and moves away from fossil fuels, that we have already seen the challenges that Ruth highlighted in extreme weather events, the displacement of communities, the lives claimed and lost in the crisis. And we say that the transition must move the country towards development that is inclusive, that protects human rights and the guarantee, including the guaranteed socio-economic rights found in the Constitution. For the past 15 years, CER has been working on a number of pieces of litigation in the environment space. But this afternoon, I just want to focus on 3 cases that are climate-related cases. And a number of the cases all these cases that I will be looking on are based on our challenges to coal-fired power as a means of exacerbating climate change. The first Ruth has touched on briefly that we worked on was Thabamedzi, which is called South Africa's first climate change case. And in this particular matter, in 2015, interesting enough, was the year that South Africa signed the Paris Agreement, ratified the Paris Agreement. In that same year, as many as 13 new private power coal plants were being planned to be developed. In 2016, 2 of these projects were moving forward, which was Thabamedzi and Khanyisa, and they were going to bring about 1,000 megawatt of coal-fired power. Environmental groups, Earthlife Africa and Groundwork, challenged this decision to pass these projects and challenged the minister's failure to take into account the climate impacts of the projects. And in their challenge, they said that the minister failed to take into account the costs of these projects. It is estimated that the country was going to lose about 20 billion rands in comparison to least cost energy sources in going ahead with these projects. South Africa is a water scarce country. The water implications were disastrous. Even from the project's perspective itself, this project was at risk due to water scarcity challenges. And even on government's own specifications, Thabamedzi and Khanyisa were designed to be high emitters of green gas emissions. In litigation, the matter went to the High Court in Pretoria, and it was set aside. The decision to pass these projects was set aside and remitted back to the minister to reconsider the approval on the basis of taking into account climate impacts, the climate impact assessment. The Minister of Environmental Affairs took back the decision and in 2018 authorized the projects again on the basis that these projects are authorized taking into account the Integrated Resource Plan, IRP, which is our energy planning process, which called for new coal-fired power, and therefore the climate impacts are considered in that plan. We launched a fresh case in 2018 challenging this decision by the minister again, and our position was that in the matter, it's not just a matter of taking into account the climate impacts considered in the IRP process. As a decision maker before you, when a project is being passed, take into account the climate implications of that decision. Outside the courtroom, when I touch these cases, I will speak to what's happening in the courtroom and what was happening outside the courtroom and strategies that lead to success. Outside of the courtroom was also modeling being done. And the modeling that came through really demonstrated that this project, firstly, is expensive from a cost perspective. And secondly, that neither Tabametsi nor Kanyisa were needed or required for South Africa's energy generation system. And thirdly, because of how expensive this project was, it was going to require increased mitigating efforts in the power sector in order to meet climate commitments. Besides the modeling, there was another strategy accompanying the case, which hanged on shareholder activism. In this process, banks were engaged that were financing this project, were engaged to say, the project that you are financing actually have these implications on the climate crisis, and your funds are funding this crisis in funding these particular projects. After months of engagements and strategy of shareholder activism, a number of banks actually pulled away until all of the banks pulled away from the projects, and the banks themselves went ahead to develop policies that would constrain their future investment in coal-fired power. The case was eventually settled with money drying up. The case was eventually settled out of court, and an order of court was made. But the success of this case is not just, as I have demonstrated in the litigation itself, being inside the courtroom. It is really just about surrounding the issue with multiple strategies accompanying the litigation, which I think is quite a useful tool as these cases are increasing to just consider that as much as we're in courts and law and litigation is playing a very potent, is being a very potent tool. There are other strategies that work well outside to accompany litigation for success. The second case I will briefly touch on is the council call case in depth. CER represented the applicants in this matter, and the case challenged was a constitutional challenge for South Africa's government's decision to develop about 1.5 megawatts of new coal-fired power generation, so new coal. And environmental groups, the African Climate Alliance, which is a youth-led group, the Vukani Environmental Justice Movement in Action. I'll speak about Vukani later again, which is a community-based organization based in the Mpumalanga Highveld, and Groundwork were the main applicants in this particular matter. And they argued in the case that government's plan to develop this new coal power plants not only threatened the rights to an environment that is not harmful to health or well-being for present generation, but it also threatened those rights for future generations, and also the rights to life, dignity, equality, as well as the best interests of the child. So here in this case, there were other rights that were brought in as opposed to just the environmental right, which is found in Section 24 of our Constitution. In this case, eventually, as Ruth says, as the matter went through court, the applicants won, and the decision of the minister was set aside for failure to take into account the implications of the decisions on the rights of children, the rights of future generation, and the nation's health, as it was demonstrated in the court, just the burden of the burning of fossil fuels on people's health. What made for success in this case, Ruth has also alluded to the amicus intervention that was present in this case in driving the matter forward. There was also quite a lot of research being done prior to launching the litigation. So expert research showing the implications of climate change on mental health, implications of climate change on children, and various pieces of research that were accompanying the case were also used in the papers for the case. I think a third key strategy besides amicus intervention and research is a robust public awareness campaign that was led by the clients themselves. Litigation, as many of us on the call will know, can take very long and can cause client fatigue when things are not moving as quickly as people would appreciate. So having a robust campaign outside of the courtroom being driven by the people who brought the case is one of the strategies that really not only led to the discourse of the implications of coal burning in South Africa into public platforms, but also sustained the momentum of young people who were in this case and leading from the front. The last case that I want to look at is the deadly air case. We consider this a climate case. Ruth has already gone into that. This case was launched in 2019 by the Vukani Environmental Justice Movement, which is this community-based organization that I've spoken about that is based in the Mpumalanga Highveld. I'll speak to the Mpumalanga Highveld in a brief, as well as groundwork, and also had individuals that came in and brought in affidavits in support of the case who live and work in that particular area. Now, the Mpumalanga Highveld is a home to a number of about 12 coal power-fired stations that are based in the area, and coal mines is an area that is suffering from extreme and toxic levels of air pollution. In 2007, after years and years of advocacy, the Highveld priority area was declared in terms of the National Environmental Management Air Quality Act. And it took another 4 years after that declaration for an air quality management plan for the high priority area to be passed. Following the plan, there had to be regulations in place in order to implement that plan. After more than a decade of that plan being passed, the area is declared a priority area. There is a plan in place. There were no regulations in sight, which really makes the plan and the declaration ineffective for the people who live and work on the Highveld. While this is happening, the levels of toxic air pollution were just rising. Even in government's own research reports, it was shown just how many lives were lost prematurely as a result of air pollution. Hanging on the case was three matters: that the toxic levels of air pollution were a violation of human rights. Secondly, so a declarator was being sought. Secondly, the right to an environment that is not harmful to health or well-being is a right that is immediately realizable. So you do not have to say, we'll wait for progressive realization, etc., like other rights are written in the Constitution. And that the minister had a duty to pass regulations in order to implement the plan. The High Court found in favor of the applicants in this case. This matter was then appealed to the Supreme Court by the minister on a narrow ground that the minister is not obliged to pass regulations. The law is written as may, therefore this means a discretion. The High Court, the SCA, I recommend that you read the judgment, authored a beautiful judgment challenging this and really confirming that under the circumstances, in fact, the minister had the duty to pass these regulations. Strangely enough, just 2 days before we went to court, the SCA draft regulations were passed, and the matter that was being argued was whether when that duty arises, whether it's a may or a must for a minister to pass regulations. One of the things that was interesting that was picked up upon by the SCA is that without these regulations, the department can't even enforce the Highveld priority management plan against the polluters. So they can't enforce the penalties that the plan was supposed to develop against polluters to be held accountable for for the air pollution in the area. One of the strategies that really made this case a success, I think it's just many years of research, many years of advocacy, and just having communities coming up and saying, this is how this deadly air is killing me. This is how this deadly air is affecting my children who can't go to school because of respiratory illnesses. This is how, and also just relying on government's own research to say, we can't have a situation where as a country, so many lives are lost when there could be something everything that is done by regulators to prevent those premature deaths, and nothing is happening. In all these cases going forward, mean a couple of things. One, that impacts of climate change must be considered in developments. Secondly, future generations must be taken into account in policy formulation. Thirdly, there is a balancing act that is required to balance human rights and the protection of human rights in energy decisions. Number four, the duty of regulators to regulate. And lastly, that polluters will have to pay for the climate damage that they are causing. I will leave it there, Crystal. Sorry, Estelle. Thank you.
Oh, Wendy, thank you so much. That was absolutely spectacular. And you touched on so many things that resonate in the UK, that activism outside of the case, and also the importance for proper remedies to be available. That suggestion of the requirement to pass regulation, super interesting from a UK perspective. Anyway, thank you very much, Chris. You're on screen. I invite you to share your slides and give us your presentation.
Thank you so much, Estelle, and it's wonderful to be here with colleagues and friends, and also wonderful to share a bit of South African climate litigation with UK colleagues. As sitting here in South Africa, we're often the grateful beneficiaries of learning from the UK, so it's also good to share something back in return. I'm going to talk briefly about the future of climate litigation in South Africa, touching on some of the successes that Ruth and Wandisa have already mentioned. I'll address two quick questions. The first is, what makes South Africa particularly fertile ground for climate litigation? And then secondly, what lies ahead and what litigation is in the pipeline? So to start off with, we've touched on some of the climate cases, but just to put that in global perspective, the Sabin Center currently has a whopping 2,900 odd cases worldwide involving climate litigation. The South African cases on that database are only 11, which is a small number, but it's highly significant because, as has already come through in Ruth and Wandisa's presentations, there are two main critical features of South African climate litigation, which are, if not unique, certainly distinct. The first one is the overwhelming success rate. So far, 9 of those 11 cases have succeeded, and the 2 that didn't succeed at first instance are, I believe, still on appeal. But the second factor is that all of those cases have been rights-orientated and grounded in constitutional rights, which distinguishes them from litigation, particularly in the United States, which is far more statutory, far more common law-orientated. Certainly statutory rights and common law rights feature heavily in South African litigation, but ultimately they're grounded in a right to a safe climate and environmental protections. So there are 3 primary success conditions that have made this litigation successful and have also provided the groundwork for the litigation that's coming. Estelle's already mentioned the strong culture of public interest litigation in the country. So this has meant that climate litigators are generally drawn from civil society and from a litigation tradition, which goes back to the anti-apartheid struggle. Many of the primary public interest law organizations in the country were born in the 1970s and 1980s in response to apartheid. And a lot of the strategic litigation techniques they developed there are still being used today under the constitutional framework. The techniques that Wandisa has already mentioned of movement-driven lawyering, using multiple strategies of public participation, public engagement, publicity campaigns around litigation, rather than pinning all hopes on the courtroom. There's also the vitally important Justiciable Bill of Rights, which I know is certainly the envy of many colleagues sitting in the UK, which I'll speak a little bit more about some of the rights that have been used. But thirdly, there's also an openness to international and foreign law, which sadly, when one looks at jurisdictions in the global north, particularly the United States and certainly Australia, there's a parochialism to the global north, which perhaps comes from colonial past, but certainly South Africa takes a far more outward-looking approach to climate litigation, draws on international law, draws on foreign law. So let's touch on briefly some of the key rights. The first and most important is the fact that we have a constitutionally protected environmental right in Section 24. That has two components. There's the 24 sub A right, which is an immediately realizable right to a safe and healthy environment, which in a number of the cases we've argued extends to a safe climate. And then there's a further right to have the state take reasonable steps to protect the environment for the benefit of present and future generations. So there's express constitutional recognition that this right extends to future generations. It's not confined to current generations. This environmental right is then attached to a bunch of associated rights: the right to life, the right to dignity, equality, healthcare, food, water. But one of the most important is the right to have the best interests of the child protected in every matter concerning the child. And that's under Section 28(2) of our Constitution. And this right and its connection to environmental rights was a big focus of the Cancel Coal case that Wandisa has mentioned. And it gives additional oomph to our environmental law protections. Finally, then, there's the openness which I spoke about. Our Constitution expressly requires courts to consider international law when they're interpreting the Bill of Rights and legislation. So that's going to have a huge impact, particularly with the ICJ's advisory opinion coming down next week. That will have to be considered in future judgments given by the South African court. Equally, treaties and soft law also are considered by our courts, including general comments. The Children's Rights Committee general comment on children's rights and the climate was certainly a big feature of the Cancel Coal case. But there's also an express power to consider foreign law. So our courts certainly do follow comparative law very closely. They're not immune to the parochialism that all courts have, but certainly there's a greater willingness and a constitutional endorsement of dealing with comparative law seriously and meaningfully. So what lies ahead? I'm going to touch on three broad channels of cases that are in the pipeline. I won't go into specifics of cases because some of it is of course privileged. And this is not exhaustive. There are many other cases which are currently either pending in the courts or are in conceptualization phase. But the three primary areas start with the focus on coal-fired power. The primary cases that Wandisa has touched on have been concerned with blocking new coal-fired power stations from coming online. And those have been overwhelmingly successful. There's been not a single new coal-fired power station brought online since the early 2010s. And all of the other coal-fired power stations that were in the planning phase or were intended have been so far successfully blocked. But we are stuck with 16 active coal-fired power stations, which are by global standards, some of the most polluting in the world. They generate 90% of our electricity and also are responsible for the bulk of our greenhouse gas emissions. So the challenge of South Africa's transition is to have a swift and just transition away from coal-fired power to renewable energy as swiftly as possible. Indeed, we look on the UK with envy after you closed down Didcot Power Station, the last coal-fired power station last year. We are still very far from that. And there are three primary battlefronts in the litigation to secure this just transition. The first is securing compliance with emission standards. The reason why these 16 coal-fired power stations are still in existence is primarily that they've been given sweeping exemptions and postponements of minimum emission standards. Without those minimum emission standards, they wouldn't be allowed to continue to operate. Those are currently under challenge. There's also litigation to remove obstacles to renewable energy development. Various obstacles still exist, lots of red tape, and certainly a lot of litigation in the pipeline to address that. And then critically, there's also the need to challenge new fossil fuel development. There is certainly a big push from vested interests to replace coal-fired power with gas-fired power. And there are many challenges currently underway to intended gas-fired power projects. Moving then on to the second broad area of pending litigation, and that's an area of litigation around loss and damage claims, monetary claims, particularly against big multinational fossil fuel companies. Most of these claims have been brought in the United States. There's not yet a single claim having been brought by or for claimants on the African continent, even though we'll bear the brunt of climate harms. But there are some features of South African law that make this jurisdiction particularly suited to future loss and damage claims like this. The first one is that our courts, once they've established jurisdiction over a multinational company or over a claim, don't recognize a doctrine of convenience. So unlike courts in England and Wales, once you've established jurisdiction, it's no defense to say that it might be more convenient to litigate against a multinational company in their home state or elsewhere. Once jurisdiction is established, the court has no discretion to refuse jurisdiction. Secondly, we have very broad grounds of standing, including a class action regime, which allows for claims to be brought on behalf of large groups of victims of climate damages. Thirdly, we also have a conducive funding regime. There's legal recognition and support for contingency fee arrangements and third-party financing. Indeed, in some of the existing class action cases, there's been a great deal of support from UK firms and UK third-party funders for that litigation. And finally, there's also flexibility in our common law in that our courts have expressed constitutional obligations to develop the common law to protect constitutional rights. So our law of delict, which is the equivalent of tort law, certainly has all of the limitations of tort law. It was never designed to deal with global damages on the scale of climate change. But our courts have an express constitutional obligation to develop our common law doctrines to address new and emerging harms like climate change. So certainly we look on with some dismay at the Australian Federal Appeal Court's judgment in the Torres Strait Islanders case. But many of those common law doctrines around negligence, duty of care would be open to development in South Africa. And perhaps there's far greater room for flexibility here. The third and final channel I want to touch on briefly is corporate accountability and shareholder activism. We certainly are studying very closely the cases in the UK and Europe around corporate accountability, particularly the Client Earth cases, derivative liability, and directors' liability, as well as questions like directors' delinquency. But there are two very important features of our law which make our companies law more conducive to these claims. The first is that our Companies Act expressly requires that it be interpreted and applied consistently with constitutional rights. So questions about directors' obligations, questions about director liability have to be answered in a constitutional framework. But secondly, companies in South Africa are also bearers of constitutional obligations. Our constitution has what was termed horizontal application. It applies constitutional obligations to private actors, depending on the right and depending on the obligation. But that means there's a strong argument that companies and directors have direct constitutional obligations to mitigate climate harms, but also to address climate harms they're responsible for. And that's certainly an argument that will be pushed very strongly in future cases. One of the key areas of current dispute is around shareholder activism. We have very broad shareholder powers in South Africa to put resolutions before companies. And that's been used very successfully by shareholder activists to present climate change resolutions at companies' AGMs. There's been an astonishing success rate. Every shareholder resolution that's gone to a vote has secured an average of over 70% support, which is far beyond the global average. But there's a big backlash from companies who are increasingly trying to block those resolutions. And that's a current case which is pending in our company's tribunal around shareholders' rights. So that's a very quick snapshot of some of the litigation in the pipeline, by no means exhaustive. But what it does show is that South African law and our legal culture is very conducive to climate litigation. But the challenge ahead is really to sustain the momentum from the existing cases and also to remain open to learning from global litigation trends. We have the benefit of a slightly later start in our litigation, but certainly that gives us the benefit of many lessons and support from other countries that have had experience of these cases. So it makes platforms like this so fundamentally important. So thank you, Estelle. Really, really appreciate it.
No, Chris, thank you so much. And as you point out, there's a lot of amazing cross-pollination that is available in this type of space, and learning from the South African litigation, both what has been and what is to come, is incredibly helpful indeed. So I'll pass on now to Lozola, and I'm just going to pop on the screen, as Lozola, given her limitations of connectivity, is not going to be on screen while she chats. I'm going to pop on a little holding slide, and Lozola, I'll invite you to give your presentation.
Thank you so much, Estelle, and thank you to previous colleagues that have really touched on some important limitations that exist in the litigation sector, especially climate litigation in South Africa. I am mainly going to talk about the regulatory perspective when it comes to, I guess, litigation, or rather challenging the status quo in South Africa, particularly from Fossil-Free South Africa. Last year, we launched South Africa's first greenwashing complaint, and we launched it through the advertising regulatory body against Total Energies. Now, the bigger reason why we launched this this complaint was also to awaken the regulatory perspective and to raise a bigger sort of challenge that is happening, in that there's a lot of cases that are going to court. There's a lot of organizations that are mobilizing toward going to court, but we are forgetting that there are already sort of departments, regulatory bodies that are already charged with ensuring that aspects of climate change do not seep through the works, and especially when it comes to advertising, when it comes to the narrative perspective, and also when it comes to essentially what is being said on the narrative waves, what is being said on TV, what is being said on radios. So we challenged Total Energies, who had a partnership with the South African National Parks. And it is a partnership spanning over 60 years, if I'm correct. The partnership has been the backbone of Total Energies, consistently claiming that they are for sustainable development and supportive of environmental protection. Now, this particular advert was a showcase of the partnership between the two. This is according to Total Energies. But the advert was an advert that was selling a product. And there is where Total Energies then made in what we tag as environmental claims, where they claim to be supportive of sustainable development and for environmental protection via this partnership with the South African SANParks. So we launched the complaint particularly on the basis that Total Energies is predominantly a fossil fuel company, is predominantly an oil company, and therefore cannot make the claim based on one partnership that they are for environmental protection or they are for sustainable development, because the advert itself made them seem like the primary business of the day is that of sustainable development and environmental protection, which is exactly where the tension was and which is why we launched the complaint. Initially, the complaint was launched in February of last year, and we received a verdict from the Advertising Regulatory Board in June last year. And the initial verdict was, it was half satisfying and not, because the initial verdict then spoke to Total Energies being a fossil fuel company, and the verdict basically stated that Total Energies cannot make the claim that they are for sustainable development, they are for environmental protection, but they can make the claim of being for sustainable development predominantly because they have the partnership with SANParks. And essentially it was a 50-50 victory in June. Following that, Total Energies then appealed the decision, obviously seeking for a more 100% victory. They appealed the decision, particularly based on jurisdiction, and we had actually presented that the initial complaint is that of Total Energies presenting themselves as though the primary point of their business is in sort of sustainable development. And their argument, as they came back, was on jurisdiction of the advertising regulatory body, which I'll touch on later in challenges, and that their advertisement should be carried still, and that the ARB basically had no jurisdiction to rule that they are not for sustainable development or they are not for environmental protection, particularly because they are not members of the advertising regulatory body. And this is just to explain to everybody else outside of South Africa that the advertising regulatory body of South Africa does have a list of members. These members then fall they are basically meant to follow the rules of the advertising regulatory body. So should there be a ruling, like I've just stipulated, the advertising regulatory body will then order, for instance, in this case, that the advertisement in question be taken down. And then it is only the members of the advertising regulatory body that will take down the advert itself. So in this case, there was an argument on jurisdiction when the appeal was launched. And then again, Total Energies claimed that the advertisement in question was not an advertisement, but rather it was an information session, or rather sharing information to their stakeholders and shareholders on a sustainability initiative that they were involved with, South African parks in South Africa. So following the appeal, this was an opportunity essentially for, I guess, us as Fossil Free South Africa and Total Energies to basically present before the ARB. And again, we did present, and one of the bigger aspects we presented on was the fact that a company cannot be for sustainable development and environmental protection, but still the majority of their business is expansion, citing projects such as the ECOP project in Uganda, citing projects such as their extreme sort of plans to fund the LNG gas project in Mozambique. So this is just an overview of the case in and of itself. And in December last year, the advertising regulatory body took out another ruling from the appeal. Basically, that's where we got our bigger victory, where the advertising regulatory body was very strongly worded about the fact that at the end of the day, there was a claim to sustainability and the claim is false. There was a claim to environmental protection and the claim is false. Now, moving on to the challenges, particularly we faced when working with regulators. There was a lengthy time in between the responses. And as we continued the work when it comes to greenwashing, there was no precedent that was set. So it kept on being a situation of there is greenwashing, there is problems that are happening based on greenwashing. When greenwashing has happened, there are implications. But at the end of the day, there was no court case in South Africa. There was no regulatory body that had come out to say anything. So in between the appeals and the verdicts and the responses, there was a gap that we faced when it comes to litigation and when it comes to a precedent that has been set. And so that was the first challenge. And also the next challenge was that the advertising regulatory body rules specifically on implicit claims. And this was one of the broader aspects that we engage the advertising regulatory body on, is that one, there should be a policy, or rather sustainability policy, that speaks to environmental claims that will come in. Because there is a rise of understanding of greenwashing. There is a rise of understanding of the harmfulness that the advertising sector that is in South Africa predominantly populated by the fossil fuel industry, that comes when there is a lack of regulation, when there is a lack of follow-up, monitoring, and evaluation. And so that was the other challenge, is that you cannot just see an advertisement and note that it is greenwashing. There has to be an implicit claim, like we are for sustainable development, we are for environmental protection. And the challenge is that a lot of fossil fuel companies don't actually make the claim itself, but they allude to it through imagery, through music, through different adverts that they put out. However, in this perspective, we did realize that when we did a deep dive research, that there were some implicit claims that we could actually continue and push for complaints. The other advantage that came out of the ARB complaint was that it pushed the advertising regulatory body to actually take seriously the recommendation that had previously been raised through Parliament to have a sustainability policy that sat particularly with the advertising regulatory body, which would make future environment challenges to false environmental claims easier. And so from the advertisement and the complaint that we put through, we did see that the advertising regulatory body has since, in 2025 May, had a presentation that they presented only to one section of South Africa, if I'm correct. It hasn't spread throughout the different cities as per the law of South Africa when there is a policy that is going to be brought about. But they do have a draft sustainability code that will make the next few greenwashing complaints or the next few environmental claims complaints easier, particularly because the other challenge that we have in South Africa is that the people that bear the brunt to climate change are communities. These communities do not have a lot of finances to challenge fossil fuel companies or to go into litigation in court. And there aren't a lot of organizations that are doing this work pro bono right up until the end. So complaints like this are very helpful in raising awareness and also having communities oppose fossil fuel companies in their communities. Sorry about that. I'm just having sound issues. And so the founding then of the sustainability code is absolutely important, and it is a victory I think we remain proud of, because quite a lot of there was a lot of media around it and a lot of understanding that it was a landmark victory, because it was the first greenwashing complaint in South Africa and Africa, and that a civil society organization won that against Total Energies. We did get a lot of air around it. It was broadcast quite widely with Radio France, and I do understand that there were some aspects, or rather, there were some departments from Total Energies that wanted to take it to court, but still to this day, we have received no court papers. There has been no further engagement on that. And then I think as I'm about to finish, before Estelle pops up on the screen, the complaint itself really did raise a different perspective for communities, civil society, and the legal perspective, or the legal people, to actually take forward. Because now we were able to not go through the courts, but rather go through a regulator and spark a policy that is actually meant to be enacted in the country to deal with one aspect of climate change. And an aspect that I believe there's been a lot of silence on, regardless of the fact that right now there is talk on greenwashing, but it's heavily because the UK organizations and different bodies are actually starting to take fossil fuel companies to court based of the greenwashing that they're perpetuating. So that's very encouraging, because I do believe that it will be a trickle-down effect into South Africa as well. So that's it from me. Thank you very much, Estelle.
No, thank you, Lazola. That was absolutely fabulous. And in fact, one of the questions that we had from our participants while they were signing up, and we'll now move to around 5 minutes worth of questions, was about the impact on European corporates of the types of actions that are happening in South Africa. And you mentioned that your greenwashing case was reported in France. Do you know if there was any specific impact on the European activities of Total as a result of your regulatory action in South Africa?
In fact, I think this is not necessarily implicit sort of reaction, but what happened is that there was a lot of local media that picked up the initial verdict. And then after, when it started moving on to Radio France and different French radio, that's when we actually had the appeal. And during the process, we noted that the team that was sent to sort of start off the appeal was basically sparked by the international sort of media and the international attention on the verdict itself. So the appeal was sparked from that. So we take that as impact. We take that as something that definitely speaks to shaking the business. But yeah, we had hoped for more. But in actual fact, I mean, having a response from Total Energies and an appeal, which gave us 100% victory at the end, was definitely more than what we had asked for.
Certainly. And if I can invite everybody else to come back on the screen. We've got one question from our live audience, which is a question for Ruth, which is about slap suits. So Ruth, if you pop yourself back on screen, I'll ask you that question first. Do you think that there'll be more SLAP suits in South Africa, or do you think that the case you mentioned, the Redl case, will nip it in the bud?
Thanks, Registan, and thank you, Sarah, for that question. Unfortunately, I don't think the case has fully nipped SLAP suits in the bud. I think that the case has shone a light on the phenomenon of SLAP suits. It has made the courts more aware of that possibility. And I think that's a very, very positive development. But it's important to acknowledge or to remember that the SLAP defense was not actually successful in the Redl case. The Constitutional Court found that recognized that a SLAP defense sort of would fit under existing defenses, specifically that one could fit it under the defense of abusive process, but then came up with specific requirements that need to be met for a SLAP to be recognized under the heading of abusive process. And in this particular case, the respondents hadn't met those requirements. They'd been relying only on the fact that the Australian Mining Company had brought the application for an ulterior motive, and they hadn't met all the other requirements. So the point is that there are specific requirements that must be met, and that won't necessarily always be met. I think that parties now seeking to rely on the SLAP defense will be able to do it more intelligently, will be able to do it having these requirements in mind, and that will certainly assist them.
Super. Thank you very much, Ruth.
Yeah.
Oh, sorry, you were about to say, but it's not put to bed.
No, but I don't think it's a silver bullet, but I think it's an important step forward.
Super. Wandisa, a question for you, because you talked about the use of evidence in the litigation, the evidence of how expensive the Thabameti coal station would be, the evidence of the impact on individuals of the air pollution. Can you talk about the challenge of relying on evidence, but in the context of public law litigation or judicial review? Because we have that problem in the UK.
Thank you, Estelle. It's quite challenging, because one of the things that this area, when you're litigating climate related matters, you find yourself in the nexus between law and science. And at times, the evidence can be dense, the research reports themselves can be dense. And I think one of the strategies that we've been thinking about is, how do you put these things forward? Ruth was talking about judicial education earlier on, but in a way that the matters themselves are not so voluminous, that judges actually avoid dealing with certain matters because it just comes in records and records. So there is that aspect of scientific-based evidence. I think one of the challenges, though, we have found in South Africa as ourselves litigating this matter is having local experts dealing with the matter, or being able to take evidence to court. You find, organizations like CAR, somebody's asking about SLAP. SLAP is just one intimidatory tactic amongst others, right? There's reputational concerns and risks. Found organizations like us taking the matters to court, like, oh, you're doing work of foreign governments, you're foreign agents, and having local partners and academics who are willing to sign affidavits and produce research is one area that still needs quite a lot of work from our side. But increasingly, people are willing, people are coming to the fore, but that needs to be balanced with just the volume that you bring before the courts.
Brilliant. Thank you very much. Chris, a question for you that just popped up on the Q&A about the possibility of damages claims and how feasible they might be given the Constitutional Court's reluctant approach in relation to constitutional damages.
Thanks, Estelle. It's a great question. The two answers. The one is that constitutional damages have so far been effectively ruled out. The Constitutional Court has said that they would only be available unless there is unless there's no other alternative. So any claim would have to first go the delictual route, equivalent of a tort law claim, but alternatively seek constitutional damages to the extent that damages aren't available under the law of delict. But certainly, I do think that there is a lot of scope, as I mentioned, to develop the law of delict to address the climate change issues. I mean, particularly around we don't have, for example, unlike law of tort, we don't have a casuistic approach to duties of care. Our approach to duties of care is far more fluid. Certainly, establishing negligence is far more fluid. And when it comes to causation, we also have acknowledged from the court that causation doesn't need to be decided on a but-for standard. The courts are open and have signaled openness to more flexible tests, including material contribution tests.
Oh, that's interesting.
Risk-based standards, which would allow us a lot of scope to borrow more from English law, which is more developed there. So there certainly is a lot of scope to use delict and borrow from tort law principles. But I think the primary obstacle really is logistical. These are hugely complex cases, enormous funding requirements, and it would really require a large amount of international cooperation to bring these cases.
Fabulous. We're a tiny bit over, but I'm just going to take 2 minutes for two interesting questions that we got from our participants at the outset. Clement Mopuli asked about the intersection between climate and disability, and if there are any cases in South Africa, either regulatory or otherwise, that are looking at that intersection between climate and disability. Anybody who can say something about that? And maybe the answer is no.
I can perhaps volunteer. Just the short answer is there haven't been cases focusing exclusively on disability, but certainly disability rights have come up in the Daily Air case and in the African Climate Alliance case. Both cases, the applicants relied on evidence, and it wasn't disputed that children, women, and disabled people are amongst the most vulnerable to climate harms. And that was common cause on the papers. But certainly we haven't had a case that focused exclusively on disability rights.
And Lazola, did you want to add anything on that?
Oh, no, I think Chris covered it. I had just thought of the ACA case that did have that line. That's it.
Super. And then just to go around the panel finally, we got a question from one of the Mishcon partners about what the importance is of climate litigation, especially in today's society. So I think that might be an interesting one to end on. So if I can ask you each just for a very short reflection on that, and I'll go the other way around. Lazola, can you start us off on that?
That's a very interesting question. And for one, there is definitely increased need for climate litigation. It is sad that there is not much funding on it, but it is absolutely important and impactful to the work that is done when it comes to climate advocacy. It also is very important when it comes to bringing up cases on or setting the precedent and a basis, in fact, for policy. Because a lot of, for instance, for us at Fossil Free South Africa, our main work isn't policy. We're trying to change policy to move towards, to move away from fossil fuel and to sort of curb climate change from a policy perspective. So litigation cases become extremely important because then it's not just social policy that is being proposed, but there is social policy based on legal documentation, based on legal cases and success rates, and even lessons from the cases that aren't won. So it's absolutely important now and even going forward. And we look forward to more cases that are brought forward when it comes to litigating in the climate space.
Super. Thank you very much. Chris?
Just to echo Lazola, I think litigation, it's a tool. It's not the only tool, but it certainly is an important one as a complement to activism, public engagement, legislative reform, and particularly in South Africa, litigation has become a bit of a lightning rod. It's been used as a tool to also develop social campaigns and awareness.
Wandisa.
Great, thank you for that question, Estelle. And just to add to what Lazola and Chris have already said, I think for me, it's just We're in a climate crisis, and it requires multiple strategies to be addressed. Already globally, we're seeing a collapse of the multilateral system. We're seeing politicians becoming less ambitious when it comes to addressing climate change. And therefore, litigation is one of those tools that could be used as a strong stick to move things forward. For me, when politicians fail, the law must be developed to hold the gaps that they create, and litigation allows for that.
Yeah. Ruth?
Thanks. I mean, so much has already been said. I don't think I'm left with very much, but there are 2 points I want to make. The first is that I think climate litigation brings together thinkers from very different spaces. We have thinkers around children's rights, we have thinkers around socioeconomic rights, we have thinkers around how things work in the commercial space. All of those are traditionally very separate areas of the law, and climate litigation is one of the areas where we really need to start all thinking together. And I think that's powerful and very interesting. And the second point I wanted to make is that I think that the tool of litigation specifically is valuable and important because it means that we bring people together and force them to answer certain questions. Whether those answers lead to the action that we want is a separate question, I think. But if you bring somebody to court, if you bring somebody to court, then they have to be in court, and certain questions need to be thought about and need to be answered. So it does lend a bit of impetus and urgency, I think, to some of the really thorny questions that are before us as a society at the moment.
Wonderful. Well, thank you all very much for your incredibly expert presentations. You have taught us a lot about the ways in which climate litigation both can be undertaken and can be used as a tool. And I think there's, as I said at the outset, a lot of opportunities for cross-pollination between our jurisdictions. Also, Ruth, touching on what you said at the end about the bringing people together from very different disciplines. I mean, that's obviously one of the things that we at Cornerstone Climate are really focusing on. And it's something that I think is a real thread through climate litigation. But thank you all very much indeed for your time today. Thank you everybody who has joined the webinar today. As I said at the outset, we'll be providing the slides and I'll add a little bit more into the slides about some of the details of some of the South African cases. So you get a little added extra for going the distance. Thank you also, and then have a look at our website for the recording. Thank you also to Will from Cornerstone for his ever expert ability to assist us through the webinar process and make sure that everything ran smoothly. I hope you all have an absolutely fantastic day, and thank you very much and goodbye.